Hey everybody, welcome into the back room. I'm Andy Ostroy. I'm really excited to bring you today's conversation with retired Judge David Tatel. He is the author of the book Vision, a memoir of blindness and justice. We'll chat with the judge in just a moment. But first, thanks for tuning in. We appreciate you listening, and we'd love to hear your comments. So email us at backroomandy@gmail.com and or post on our social media, and we'll read some feedback next time. And if you like the podcast, please follow or subscribe and rate and review, and you'll be notified every time we post a new episode. So let me tell you about Judge David Tatel. He served on the United States Court of Appeals for the District of Columbia Circuit from 1994 to 2023. Prior to that, his 3-decade career as a civil rights lawyer included private and government positions. He also served as director of the Chicago Lawyers Committee for Civil Rights under law, and then director of the National Committee. He was the director of the Office for Civil Rights of the U.S. Department of Health, Education, and Welfare during the Carter administration, and when he returned to private practice in 1979, Judge Tatel joined Hogan Hartson, where he founded and headed the firm's education practice until his appointment to the D.C. Circuit by then-President Bill Clinton. Judge Tatel also co-chaired the National Academy of Sciences Committee on Science, Technology, and Law. Judge Tatel, welcome into the back room.
Thank you. Good morning.
So you retired earlier this year. Tell me what retirement is like.
Well, yes, it isn't anything like I expected, basically because the aftermath of my book is another full-time job. So I feel like I've gone from one full-time job to another full-time job. And so the answer is I haven't yet experienced retirement. And when I do, happy to tell you what it's like.
So you haven't gotten to that point yet where your wife, Edie, who we will talk about at a few points in this conversation, she hasn't begged you to go back to work yet?
No, not yet. No, I'm not even close.
And you've had such an illustrious career, which was sort of evenly divided between being a civil rights attorney and a judge, which spans roughly 60 years. Why did you choose this year in particular to retire? Was there a specific motivation or a trigger moment that made it happen this year versus last year or 5 years ago? Or next year?
There wasn't a trigger. No, it wasn't a specific moment. It was a gradual decision to retire. I first took senior status, which is a position where you can carry a lower caseload. And a lot of judges stay in that position for quite a while. But I decided to retire completely. There were a couple reasons, Andy. One was, even though I loved the job up to the very last minute, I never wanted to stay in it forever. Federal judges have lifetime appointments, and we can stay, as the Constitution says, for good behavior. But I always thought it was healthy for the institution, for judges not to overstay their welcome. And I wanted to retire at the top of my game, not later when things might start happening health-wise. So I always had that in mind. The second reason was that I became increasingly, federal appeals court judges are bound by the decisions of the Supreme Court. We have to apply their decisions to our cases. They are binding on us. And for my first 20 or so years on the court, I had no problem with that, even when I disagreed with a Supreme Court decision. As long as it was a legitimate act of judging, followed the rules of judging, I followed the opinion in my future cases. The Supreme Court is the highest court in the land. If they disagree with me, that's fine. That's their job. Mm-hmm. I'll do what they tell me to do, as long as their opinions are principled. But in recent years, I've been increasingly concerned that the Supreme Court has abandoned the basic principles of judicial restraint that are essential to preserving the separation of powers. And particularly in the past 2 or 3 years, I am concerned about how the court reached some of its more controversial decisions, and found myself uncomfortable having to apply them. So I thought it was healthiest for me and the court, for me to retire and let someone else figure out how to do this.
Mm-hmm. And I'm going to talk with you about the Supreme Court later in the conversation, but I just want to make an observation based on what you just said, which I find really interesting, because as a judge, as someone who spent 3 decades in the court system, if that's the way you feel, imagine how the rest of us out there who don't have a law background, who are just average citizens looking at this court and watching its decisions and seeing how politicized it's become. Imagine how we feel.
Yeah, well, that's a really good point, Andy. And I talk about that in my book. I talk about why, I ask the question, why is it that the court's public approval ratings are so low these days? And I try to at least articulate 1 or 2 reasons for that. So yes, that's exactly right.
The book is called Vision, a memoir of blindness and justice. Came out a couple of months ago. Congratulations on that. We're going to talk about that. So let's go back in time. I believe your vision became an issue in 1954. You were 12 years old, and I think there was an incident on a baseball field. Describe for us what happened in that moment and how long it took before you eventually lost your eyesight due to retinitis pigmentosa.
Yes, I was a totally obsessed baseball player as a kid. And I was standing in right field, and I got hit by a ball that I just didn't see coming. And even as a young kid, I wasn't sure what that was all about. But this wasn't the first indication that something was wrong, Andy. I could never see very well at night in the dark. Even, as a really little kid, I couldn't see well at night. And, I would complain about it. And some people would say, well, yeah, you can't see at night because it's dark at night. But my parents were concerned, but the doctors had no idea what it was. Mm-hmm. They told me to eat carrots. And I ate a lot of carrots. And I still like carrots. But it was the combination of the increasing difficulty of seeing in the dark and that being hit by that baseball that ultimately led my mother to take me to the National Institutes of Health, where they diagnosed the RP when I was 15 years old.
Mm-hmm. So the inability to see 100% clearly in the dark wasn't necessarily a red flag as the incident on the baseball field was.
Yeah, to me it was. It was a bit of a shock because I was a pretty good ball player, and that was a real shock to me. And then afterwards, things like that kept happening. I would position myself I would always try to position myself in the outfield to be sure there was, for example, a tree behind the batter, because then it was easy for me to see the contrast between the white ball and the dark background. So I was doing all kinds of tricks like that. So I knew something was wrong, and my parents did. But this was 1957. Watson had just at that point was just barely discovering the double helix. We didn't know much about genetics, and ophthalmologists then had no idea what my problem was. Mm-hmm. And so it wasn't until I went to a really serious expert that they diagnosed it.
And was the loss of vision over the next 18, 20 years or so, was it a slow progress? Did it accelerate at some point? What was that period in between the baseball incident and that moment like?
So everybody's experience with RP is different, but the trajectory is generally the same. For me, it was a very slow decline. Mm-hmm. So the night vision slowly got worse. The peripheral vision and the central vision both became, there were more and more parts of my vision that I couldn't see, that were blocked. Some of them were central, some of them were peripheral. But it was all very gradual. So I was 15 years old when I was diagnosed. Not until age 35 did it take a precipitous drop. And when I was 36 years old, it deteriorated very rapidly. I could sense it over the years because I kept getting my eyes tested. And I tell the story in the book about how, when you go to take these tests, they have this peripheral vision test. I'm sure you've taken one. My guess is your listeners have. And you look at a dot and they ask you to tell you, can you see it? Can you see it? Can you see it? And when you can't, you say no. And, over the years, I saw, I had more no's than yeses. So even I could detect it deteriorating. But at age 35, it took a precipitous drop. And at that point, I switched to, I said to my secretary, hey, you need to read me this letter. I just can't read it. I discovered audio books at the Library of Congress, and I started to learn Braille. That'll in 1 year.
You write in the book, quote, "Hindsight is 20/20, but memory isn't. I think the truth is that I was deeply in denial and just trying my best to get through each day as it came." It wasn't until the process of writing the book with your wife, Edie, that you finally began to reconcile and accept your blindness. Help us understand that journey to finally being at peace with it.
It's a really great question. When I started writing this memoir, I thought all you did when you wrote a memoir was you write down, you record your life. You start at the beginning and go to the end. Little did I know what a deep, profound experience writing a memoir would actually be. Fortunately for me, I had a wonderful writing partner, my wife, who was also part of the story. I mean, this is my memoir, but it's also a memoir about our almost 60 years of marriage. I mean, she's experienced blindness also with me. So during the process, both because I had a really good editor who asked me very hard questions, and a few close friends who did also, and Edie, I, during that 3 years, explored, thought about issues about blindness and why I reacted to it the way I did and how it affected our marriage. That I'd thought about them before, but never seriously and systematically. And the process of writing the memoir, of getting more comfortable talking about it with my wife and with the editor and with other people, made me more comfortable with the blindness. And I'm sure you'll get to this later, but so did finally having a guide dog. But I really had no idea what a profound experience the memoir writing. I say in the prologue of the book that the memoir is itself a coda to my life adventure. In other words, it was the coda. That's the word I chose, and it truly was. My views about blindness and myself are very different now than when I started. In fact, if you had called me 5 years ago and asked me to come on your show and talk about blindness, I would have said no.
Well, I would imagine it's a hard thing to look at one's life. When you do a memoir, the good memoirs, the great memoirs are inclusive of the good, the bad, and the ugly. A lot of memoirs gloss over the bad and the ugly, and they just kind of glorify the good. And there's not as much truth in those as the ones where people really bare their souls. I mean, I made a film about my late wife who was murdered in 2006, and I put it all on the table. That's a different medium, but I would imagine for you and others who write memoirs, it puts you through a traumatic process because it forces you to look at all parts of your life, including the parts you don't like, the parts you hate, the parts you may be ashamed of, etc. But that's what makes them great.
Yeah. I'm not sure I'd use the word, at least from my experience, traumatic. It wasn't traumatic. It was difficult. I remember so many times when Edie or my editor or one of the other wonderful people who helped me with this would ask me a difficult question, like, they would say, well, how do you think? Do you think differently than other people? Well, I sat down to try to write that, and that was really, really hard to try to explain how one thinks without sight. I mean, I came up with my own conclusions about it, but so it wasn't traumatic. It was just difficult, but it was also extremely extremely rewarding in the end because I feel so much better about the whole process. The other thing that maybe we'll get to this later, but I just don't want to forget
Go ahead.
to say this. This is such an important part for Edie and me about this book is what's happened since then. We have been so surprised that since this book came out in June, I get 2 or 3 emails a day now, many from people who I don't know, who say, you've told my story. So when people read memoirs, yes, they're reading a memoir to read about an interesting life, but they also see themselves in the book. And there are many, many people who had RP or other genetic eye diseases who wrote and said, you've told my story. And that's important to me for 2 reasons. One is, I wrote the book in a hope that it would be inspirational. But more important, when I was going through this as a teenager and then a young man, I thought I was alone. I didn't think anybody else was doing this, which is why I hid it, I think, or one of the reasons. I didn't have anybody to talk to. Now I'm suddenly discovering after writing this book that I wasn't alone and that many, many people, in fact, most of the people who I've talked to who struggled with the decline of sight actually responded to it in the same way I did. They hid it, they covered it up, and it's been a real revelation for me to know that.
Well, that is a motivator for a lot of people who do write memoirs because an author is a storyteller, and the greatest stories are the stories of people's own lives. Yours is a truly inspiring story. It's one of great courage and resilience and determination. And so based on what you just said, you clearly have become, or are you, let me just ask you, are you comfortable with the notion of being that kind of role model for other people?
I am now, absolutely. And I hope that's what this book will do. I hope that, people, you'll see in the book, Andy, that role models were very important to me. Judges, lawyers, great civil rights lawyers, they were really important to where I went and how I got there. But I didn't have any blind role models. There were no blind judges. There were no blind lawyers that I knew of. And so, you look back at young David Tatel, who was hiding his declining sight, and you say, why did you did it? Well, it wasn't surprising, right? He was worried that this could adversely affect his future career because he didn't have any role models of people like that. And so, I hope, this book and my now comfortable talking about it might supply that. As I mentioned to you earlier, I listened to your interview with Melissa Eddy, who wrote the biography of Chancellor Merkel. And she said to you, I was really struck by this. She said, what a profound, and that's the word she used. She said how profound it was for her as a woman writer, writing international issues, to see that the Chancellor of Germany was a woman. And so maybe young people going through what I went through will read this book and see that, they too can become a federal judge someday.
And just to dig a little deeper on that subject, what advice or words of wisdom would you have for other folks who have either lost their sight or are struggling with other health-related conditions that have impacted their daily lives in such a profound way?
Well, I can only talk about blindness. I don't have the experience with anything else. And everybody's experience with blindness is different. So it's really hard to give advice. I think the world today is very different than when I was losing my sight. Technology has made an enormous difference. And so it's a lot easier to be blind now than it was 50 years ago because of technology. And I think, my advice to young people is, first of all, to learn to type. When I was in the 7th grade, boys took shop, and girls took typing. I never learned to type. And that right now is a severe obstacle for me because because blind people, anybody who has no sight, can use a regular computer just like anybody else now, and can do everything a sighted person can. I've seen law clerks in my court, a couple of blind law clerks, and they function just as smoothly and efficiently. Now, there's some things they can't do, but their access to data, to information is 100%. And that's because they know how to type. So the first thing is learn to type. And if you learn to type, then you can do all kinds of things. The other thing is, I guess, I think that we now have the Americans with Disabilities Act.
Mm-hmm.
When I was losing my sight, the unemployment rate for blind people was enormous. It's still not great, but it's better. And so I think young people don't have to hide it the way I did. I think it's possible to be more honest about it. And with technology, to adapt faster than I did.
Mm-hmm.
That's the advice I'd give.
We all want to be judged for who, not what we are, or especially by a disability we may have. What was your process for fighting something so pronounced in your life so that it doesn't define you from a personal and career standpoint? What were your coping mechanisms, especially as a younger man?
Well, I'd say the main coping mechanism was, first of all, hiding my blindness, my declining sight as long as I could. And in the book, I tell all the stories about, how I functioned with declining sight without having to admit to anybody that I had it. A lot of the stories are funny. A lot of them aren't so funny. So first was hiding it. And then when it became impossible for me to hide it because, I was using an aid to walk around, or I ultimately got a cane, I just never talked about it. I did not want to be known when I was a lawyer, as a blind lawyer. I wanted to be known as a lawyer who happened to have a visual disability. And when I was nominated to the court by President Clinton, I wanted to be known as the judge, not as the blind judge, but as a judge who happened to be blind. Mm-hmm. That's a big difference to me. That's a huge difference in my mind. Mm-hmm. It may not sound like a big difference to other people, but to me, it's a really significant difference. I think that I spent my 30 years on the court. When I was nominated, the president didn't mention that I was blind, but the press reported that I was the country's first blind appeals court judge. Or, I didn't want to be known that way, but the facts were the facts. And I suspect that during those 30 years, why did I work really hard to try to be a really, really good judge? I think because I wanted people to understand what I knew, and that is that I was a really good judge who just happened to be blind. Mm-hmm. So, I don't know. Does that answer your question?
Yeah, quite aptly. We touched on this a little bit earlier about your wife, Edie. What role, and by the way, congratulations, 60 years of marriage. You should win an award for that alone.
Yeah,
that's pretty amazing. What role did she play?
And we knew each other for only 4 months before we got married. How about that?
I'd consider that a major return on investment.
Yeah.
If this was Wall Street, you'd be a trillionaire. What role did she have overall in the researching, writing, or even conceptualizing of the book? Give us the full flavor of her role, not just in writing the book, but the impact she's had on you in those 60 years in your life.
Well, I said at the beginning that this is a book about both of us and about our marriage. I mean, Edie was the first person I ever actually told about my declining sight when we were dating. I had really never told anybody else about it. So she was the first person I ever really sat down and explained to her. And so, Edie has lived this life with me. She's lived the life of declining sight and of finally losing my sight, and the whole process. She's been she's been part of it. And my blindness affected her probably as much as it did me. And much of the book is about that. Much of the book is about how we managed our lives and with our growing family with blindness. And, we tried to be, we didn't try to be as honest as we could. We were as honest. We were honest and forthright about it. There's a lot that's not in this book. I'll be honest with you about that. Mm-hmm. But we told our story. And so when I got to writing the book, the fact that I never written a book before. And I found the whole experience intimidating at the beginning. But partway through the process, Edie just rolled up her sleeves, and we ended up working on it together, which, I would write, send stuff to her. She would edit, return it. She would write stuff, send it to me. We would sit. I'm sitting right now. I'm talking to you from the second floor of our house in rural Virginia. It's a very long desk overlooking the trees outside. I'm on the right. Edie's computer is at the left. We spent months here next to each other, her on her computer, me on my Braille computer, working, talking, arguing, debating, exploring issues, writing stuff, throwing it out. And, slowly, very slowly, the book emerged. And it did it because I think the reason why we're so pleased with it, and it's had such a good response, is that she wasn't just a writing partner. She was part of the story. And so therefore, I think the observations that we make are more accurate and more interesting. When you see quotes from Edie saying things, where those are from is she wrote a very long memo of her own early in the process. I don't know, 10, 20 pages, just of all kinds of thoughts, experiences, remembrances. And in fact, we had each of our kids. We sent our children. We have 4 kids. They're all adults, and they all have their own kids. And we had all 4 of them fill out a questionnaire about what it's like to grow up with a blind dad. So the quotes that are in the book from Edie and from the children are from those documents. That's where that comes from. So, yes, so this is a book. The memoir is a memoir really about Edie and me and our lives together and our lives dealing with and adjusting to blindness. That's what the book's about.
You said this is your first book, but you've written so many opinions over the years. Is there any connection, any similarity? Were you able to use your experience writing very lengthy legal opinions in writing the book?
It's a totally different approach. A legal opinion has a structure. You know what they look like, and you fit your opinion into that structure. It starts out with facts, and then it has legal analysis, and it's an analytical document. I would say in a part of a legal opinion that's most like writing the book is the fact section. I work really, really hard on the fact section of my opinions, which appears under Roman 1 in an opinion, to make them clear and concise and understandable. And to that extent, writing a memoir is very similar. But it's also very different because my audience is so completely different here. When I'm writing an opinion, it's important that judicial opinions be understandable by the public. It really is. Because why does the public accept the decisions of unelected judges? Because they have confidence that they're legitimate acts of judging. And how do they know that? They read the opinion. So it's important that the public be able to read opinion. But to be candid, I don't know how many members of the public were able to read an opinion from the about the Federal Energy Regulatory Commission or the Food and Drug Administration. They're pretty technical. But even so, I tried to make them understandable. When I was determined at the beginning of this, when we wrote this memoir, not to write a book for judges and lawyers. I did not want it to be a book just for judges. I wanted it to be credible enough so that judges and lawyers would find it credible. But I wanted the public, I wanted non-lawyers to be able to read it. I wanted, young people to read it. And that was one of the biggest challenges, was writing in a way I wasn't really accustomed to. And that's one of the great values of having E work for me. Since write with me, since, she's a much better writer in that form than I was. So that was the biggest challenge, I would say. The only other thing is, I would say, I read a couple of books. Edie gave me some books about memoir writing to read before we get started. And one of them was, always tell the truth, trust your reader. Well, that's true in a judicial opinion too. Same rules.
Mm-hmm. So let's talk about the other big influence in your life and in terms of the process of writing the book. And we talked about your guide dog, a German Shepherd named Vixen, a little bit before. In the book, you say that Vixen has changed your life, in particular, helping you to accept your blindness, which really is a beautiful sentiment. How has Vixen changed your life?
So for years before I had a guide dog, I used a white mobility cane. Mm-hmm. And, when you have a cane, when you're walking down the street, you're obviously a blind person, but people aren't talking to you about it. People don't walk up to you and say, hey, that's a really cool cane. Or they don't walk up to you and say, how are you going to get across that street you're coming to? When you have a guide dog, you are obviously a blind person, but people want to talk to you. Mm-hmm. How's that dog trained? What's your name? Can she really get you across that street? And I have lots of these conversations. Whether, I'm standing on a corner waiting for the light to change. Somebody wants to talk about the dog. I'm on the metro. That's our subway in Washington. Mm-hmm. People want to talk about the dog. You can't have a guide dog and not be a blind person and talk about it. And particularly here in the country, we live in rural Virginia, and Vixen and I go on long walks. Drivers stop, want to chat about the dog. Dogs, I say in the book, dogs bring people together. And her presence in my life made me more comfortable talking about it. The other thing is that, at least for me, Andy, and I can only speak for myself, there's so many things you can't do when you can't see, that it's really important to do as many as you can by yourself. Mm-hmm. So independence is the gold standard for me of accessibility. I want to be able to do stuff by myself. So for example, it used to be 30 years ago, I had to have Edie or friends or other people read me the newspapers. Now I read them myself, independent, all by myself. Same thing with Vixen. When I go out for a walk now, Vixen's right next to me here. She won't be insulted when I say, I'm doing it by myself. I'm really not. She's guiding me. But there's no other human involved in it. We don't have to talk about where we're going or watch out for this curve or do this. It's all instinctive with her and me. And so you have this enormous sense of independence when you have a guide dog, which I guarantee you makes you more comfortable talking about blindness. Mm-hmm. I say in the book at one point, sometimes when I am walking along these beautiful roads in rural Virginia here with Vixen, and there's nobody else around, it's just Vixen and me, and, we're walking along the river and there's birds, I actually stop even thinking I'm blind. It's totally amazing.
What a truly amazing gift.
Yeah, it's quite amazing.
Let's talk about the career a little bit. You spent 3 decades as a civil rights lawyer in both private and government positions with a heavy focus on equal educational opportunity and access to justice. When so many young people today go to law school with the goal of ending up at a white shoe firm to make big money, what compelled you into this specific area of the law?
In the 1960s, when I was a student at the University of Michigan, I was fortunate to have a summer job. The Kennedy administration brought thousands of college kids to Washington each summer, and they gave us real jobs. And I was one of them. And it was the early 60s. The civil rights movement was at its height. You know, the papers were full of freedom rides and sit-ins at the lunch counters and fire hoses and you know, everything, the whole civil rights movement. And I was really focused on the civil rights movement as a kid, as a young man. And also, University of Michigan was a hotbed of protests and marches, you know, so we were part of it. And I observed the Justice Department, the Civil Rights Division, this is Robert Kennedy's Justice Department, these great lawyers going to the South and bringing these cases to court and standing down George Wallace. And I was totally enamored with what they were doing. I thought, that's what I want to do when I grow up. And that's why I went to law school. I wanted to be that kind of civil rights lawyer. Mm-hmm. And I was also really impressed with the judges, the federal judges in the South, who, you know, even though they came from the South, they took an oath, they got a life, they took their oath of office and they took it seriously. And they enforced the Constitution, the 14th and 15th Amendments. And that's what I wanted to be when I grew up. And I was just determined. And fortunately for me, the opportunities came along at the right time. And one opportunity led to another. You know, running the Lawyers Committee for Civil Rights Under Law, which was created at the request of President Kennedy, heading the Office for Civil Rights at the Department of Health, Education, and Welfare during the Carter administration, and then 15 or so years doing civil rights work as a litigator. I was very fortunate that these opportunities came up at the right time. And to go back to what I said earlier, I had these great mentors and role models who helped me along the way, you know, in terms of opening up possibilities, advising me about what direction to go in. And so for me, it worked out really quite well. I loved that part of those 30 years of my career. I found them very satisfying.
Describe for us the role that you played in the challenge to the 1965 Civil Rights Act, which was eventually gutted in 2013 by the Supreme Court.
Yeah, right. Emphasize the word gutted. So the Voting Rights Act of 1965, the key to the vote, viewed by most people as the most successful civil rights law ever passed. And that's because of what's called Section 5 preclearance. And the Voting Rights Act of 1965 selected a subgroup of southern states that had the worst history of discrimination on the basis of voting. It selected those states, and it required them to submit any voting change to the Justice Department and prove that it wouldn't be discriminatory. And it was dramatically successful. And the Supreme Court sustained the constitutionality of that law 4 times. And they relied on the 15th Amendment, and particularly Section 2, which gives Congress the authority to enforce the amendment. And what the court said was that the Voting Rights Act brought about a dramatic realignment of the relationship between the federal government and the states. And it gave Congress all the control it needed over the states to rid these states of discrimination based on voting. And the Supreme Court relied on that 4 consecutive times. Well, and Congress extends the Voting Rights Act. I think it was in 2006 they extended it. And this time, in 2 decisions, one called Northwest Austin and one called Shelby County, the court eventually declared the formula underlying Section 5 unconstitutional. And my involvement in that was that when you're on a court of appeals, you don't pick your cases. Judges are assigned randomly to cases. And I was randomly assigned to the first case, Northwest Austin, and I wrote the opinion in that case, which is sustaining the constitutionality of the act. The Supreme Court reversed it, but didn't declare it unconstitutional It was able to decide the case on a narrow question. But it warned Congress. The Supreme Court warned Congress that this statute had serious constitutional deficiencies. Well, Congress, being Congress, didn't do anything about it. And 5 years later, case came back. I was randomly assigned to the next case, which the name of which everybody knows, Shelby County. Mm-hmm. It's a voting county in Alabama. And again, I wrote the opinion sustaining the Constitutionality Act. This time, the Supreme Court 5-4 declared it unconstitutional. And so that's and I describe this. I have a whole chapter in my book called "The Future of Democracy," and it's about these two cases, and it's about my concerns about the case. And there's two levels of concern. One is the one everybody's focusing on, which is as a result of Shelby County, voter suppression in the South sparked up. And we're seeing the results of that today. Extensive efforts to prevent people from voting. And this is all happened because Shelby County made it possible. The other side of the issue, the other concern, and this is why I wrote the book, really, or at least in this part of the book, is my concern about the way in which the court declared it unconstitutional. It wasn't a principled act of judging. Instead of following its precedent, which courts are supposed to do, which had rejected constitutional challenges to the act, instead of following its precedent, which made clear that the 15th Amendment gave Congress all the power it needed to prevent the states from discriminating, it wrote an opinion that's all about state autonomy and federalism. They hardly even mention the 15th Amendment. They talk about the 10th Amendment. Mm-hmm. It's an opinion that turns the 15th Amendment upside down. And it's I like to put it this way. If you were an originalist, Shelby County would have been an easy decision because there's hardly any provision or constitution that's clearer than Section 2 of the 15th Amendment in giving Congress the authority it needs to rid the country of racial discrimination in voting. It's about as clear as it gets anywhere in the Constitution. Yet this court, on a straight political vote, 5-4. By the way, I mentioned that the court had sustained it 4 times. By my count, that included 29 justices, both Republican and Democratic appointed justices over those years. 29 of them, there were only, as I recall, 6 dissenters. So now in Shelby County, the court, on a strict partisan vote, the 6 Republican-appointed judges, the 5 Republican-appointed judges in the majority, 4 Democratic-appointed judges in the minority, strikes it down on a theory that had not only no support in its case law, but it did it on the basis of a made-up principle called equal state sovereignty, which the court's earlier decisions made clear applied only to the admission of states to the Union. And the court took that doctrine and said that it was unconstitutional for Congress in Section 5 to treat the southern states differently, that it violated this court-made doctrine. You won't find it anywhere in the Constitution to treat these states differently, even though the plain language of the 15th Amendment said just the opposite. So that's a long answer to your question. But the reason it's in a chapter called The Threat to Democracy is because I worry that judicial decision-making of this type is a threat to democracy, because you have the unelected Supreme Court substituting its own views for those of the elected branches of government, namely Congress. That's not healthy for democracy.
No, and, I want to talk about the Supreme Court in a few minutes because the court has become so politicized, and you look at decisions like the presidential immunity decision, which is terrifying. But what do you consider your most satisfying moment on the bench, as well as one that was the most frustrating and upsetting? And perhaps maybe we just talked about that one.
I think you probably talked about the one that was most upsetting. To me, for someone like me who, I have my own theory of judging. I talk about it in the book. I have a chapter called The Art of Judging. I care deeply about it. I think it's important to our constitutional system, and to have the court so blatantly violating it it wasn't just that they reversed me. I've been reversed by the court before. And as I said earlier, it's okay. It's their job. And in fact, Andy, there's a way they could have written this opinion that would have been principled. I wouldn't have liked it, but there was a way you could write an opinion, striking down Section 5 and giving Congress time to fix it. It would be a different theory. It would be easily fixable by Congress, but it would be a principled position. It wouldn't be a blatant violation of the court's precedent and of the plain language of the Constitution, but they chose not to do that. So to me, that was a very demoralizing experience, but so have the recent decisions of the court. It's much more fun to talk about the best parts about it.
Mm-hmm.
And I can't pick one case because being on the U.S. Court of Appeals for the D.C. Circuit was such a satisfying experience for me as a lawyer. I loved the whole thing. I loved the cases. I loved the process of deciding them. I loved working with my colleagues on them. The best part of the job was the whole job. Sure, it's really fun to write an opinion that ends up on the front pages of the New York Times. But it's just as satisfying to write a really good opinion in a case no one will ever hear about if you get right and it's clear, and it's satisfying to take a case, think about it deeply, read the briefs, hear the arguments, write the opinion, and get it done. That's very satisfying. So I love the whole job. Were there some cases? Yeah, there were a couple cases that I kind of got tired of near the end, but not too many. As I said at the beginning, I loved the job right up to the day I left.
How do you think the Court of Appeals and the judicial system overall has changed in that span of your career to where we are now?
Far more politicized. It's
Mm-hmm.
more politicized.
Mm-hmm.
It used to be that confirmation hearings were just routine for the Supreme Court and for everybody. Even when I was confirmed in 1994, not only unanimously, but on the consent calendar. If I was nominated today, the vice president would probably have to break the tie.
Mm-hmm.
So, the confirmation hearings, even at my level, the federal appeals court and district court level, have become huge political battles. Not to say, we all know about the Supreme Court. Those things go on for 3 days, right?
Mm-hmm.
And they're handled like political campaigns. And that's now true in the federal courts. And we're all now paying the price for that. And the other reason we're paying the price for all this, in terms of the increased politicization of the court, you'll probably be surprised to hear me say this, but I think one of the most serious, one of the most damaging things Congress did was to get rid of the filibuster for judicial appointments.
Mm-hmm.
I don't like the filibuster generally, but the filibuster actually played an important role in judicial appointments because it required the president to get support from both parties for his nominees. You could not, it had to be, at least to some extent, bipartisan. And that kept a lot of extremists on both sides off the courts. But when the Senate got rid of the filibuster, first for my court, all the courts of appeals, and then for the Supreme Court, it opened up the floodgates. And we're seeing the consequences of that now with the courts are much more ideologically divided than they were 15, 20 years ago.
With the court being so politicized, and then also the scandals, the ethics violations, Clarence Thomas, Samuel Alito, people like me would look at the court and go, my God, we need a code of ethics, we need this, we need that. But for me, the court seemed to have jumped the shark earlier this year when I was watching the immunity hearings. And I sat back and I was like, am I really watching lawyers for Donald Trump, go into the highest court in the land and argue that he should have the ability as president to use our military to assassinate his opponents. And it became like a legit conversation in the Supreme Court. And I was like, am I delusional here? What's going on? Like, how is this happening? Are we at a point where the court has just, it's gone too far and there's no turning back? How do we fix this mess?
Well, the immunity decision, fits the pattern that worries me. Yes, you talk about the consequences of it. And there's a big debate about what the consequences of it. What's more concerning to me about the decision itself is the same concern I have about Shelby County, which is that it's unprincipled. Mm-hmm. There's no support for former presidential immunity in the Constitution. It's just not there. And the decision, the decision is not even faithful to the court's own precedent. In the Nixon civil case, it's called Fitzgerald, where the court ruled that President Nixon was absolutely immune for civil suits. All 9 justices distinguished it between criminal law. They said it's totally different from criminal law. The nation has a big interest in ensuring criminal laws are applied to everybody. Well, now we have this court, which, and by the way, now we have, and before that, by the way, was the Nixon tapes case, where a unanimous Supreme Court ruled against Richard Nixon, again emphasizing the importance of enforcing the criminal laws. You read this opinion now, and not only is nothing in the Constitution supported, but it's all about protecting the president. Mm-hmm. They somehow think that future liability will restrain or limit a president's ability to carry out his Section 2 authority. Well, where did that come from? I mean, there's nothing in there about the importance of enforcing the criminal law. So to me, what's wrong with that opinion, what's really wrong with it is just like Shelby County. It's an unprincipled judicial opinion. Now, you ask a really hard question. What do we do about it? Well, today's paper is full of a big story about legislation that's been introduced to change the structure of the court and do all kinds of other things. I'm not going to get involved in particular pieces of legislation. That's not my job, but I'm a skeptic about that. I think, first of all, I think it's not going to happen for both political and constitutional reasons. And I also think, to make a good argument, that it shouldn't. I actually think term limits would be a good idea, but that's not going to happen. Mm-hmm. I don't think restoring the filibuster will happen either. But in the long run, if we could restore the filibuster for judicial appointments, I think in the long run it would solve the problem. In terms of ethics, I've been very careful, Andy, not to talk about ethical obligations or experiences of any individual judge or justice. I only talk in the book about my own standards for recusal, but I do think that the federal courts at my level, we functioned under a very clear ethics code, which I thought worked very, very well. I can't think of any reason at all why the Supreme Court shouldn't operate under a similar ethics code. Maybe there are, it's very debatable about whether Congress can impose it on them. There are arguments on both sides of that. If I were a senator, I would say, look, it's not clear one way or another, but I took an oath to uphold the Constitution also. And I believe an ethics code would be constitutional, and pass it. I'd vote for it and see if the Supreme Court wants to declare it unconstitutional 6-3. I don't know whether they will. Mm-hmm. But I think an ethics code would be a good idea. People talk about mechanisms for enforcement. One idea people have talked about, I think there's legislation that's been considered for years, is maybe a inspector general for the judicial system. Mm. I think that might be I haven't thought it through completely, but as long as it was clear that the inspector general couldn't have anything to do with judging, it was only on other issues, inspector general might might be helpful to bring light to what's happening within the courts. I think there's lots of things. And here's the other thing. A lot of what the court has done can be fixed by Congress. I can't fix the immunity case. But, all the decisions the court issued at the end of the term limiting what federal agencies could do, that Congress can fix. Congress can fix the Supreme Court's decision in the Bumstock case, the gun case involving Bumstock. Mm-hmm. Congress can fix a lot of this. And the problem with our Congress, it's generally dysfunctional, but it acts from time to time. Congress is the most important check in our system of checks and balances. It can check the Supreme Court. And all the energy we're putting into, fine. If people want to advocate for a constitutional amendment, great. But we should put as much energy into figuring out how to convince Congress to step up and fix some of these problems itself. Mm-hmm. So that's a long, rambling answer to your question. But
no,
it was a hard.
Makes
it was a hard
sense.
Question.
On the subject of recusals, tell us what the Tatel 5-minute rule is.
The Tatel 5-minute rule. So my rule was, if I had to think about something from an issue, if a recusal question came up, should I sit on a case? And I talk about these in my book, either because of my blindness or for something else. Maybe I knew one of the lawyers, or maybe I had done something in my past that was relevant to it. My rule was that if I had to think about it, if it took me more than 5 minutes, if I didn't have an answer within 5 minutes, I recused myself. Because my theory behind that was that it's critical for the proper functioning of our court system that the public has confidence that judges are impartial, because we're unelected, right? I mean, they can't go to the voting booth and vote against us. They have to understand and be convinced that we are impartial. And if it took me 5 minutes to decide whether I should or shouldn't, I decided, okay, I'm going to err on the side of recusal. And I did it. That was my rule. Now, you asked me the question, so I want to say this one thing about the Supreme Court. It's very different for a Court of Appeals judge to recuse himself or herself than a Supreme Court justice, because when I recused myself on my court, another judge replaced me. Mm-hmm. So there was still a judge panel that could decide the case. Supreme Court, all 9 justices sit for every case. So if a judge recuses herself or himself, then there's only 8. And that's not good for the court. So I accept the idea that, and this is reflected, I think, in the court's own statements, the justices' own statements. They're right. Justices have a real duty to sit. But to me, Andy, that carries with it a parallel duty to lean over backwards to make sure that you're not in a situation that would require you even to invoke the 5-minute rule. So that's the Tatel 5-minute rule.
Well, I'm going to say amen to all of that, because it makes a lot of sense. Judge Tatel, thank you so much for coming on. This was a really interesting conversation. And good luck with the book. Again, it's called Vision, a memoir of blindness and justice.
Thanks, Andy. I enjoyed our conversation.
All righty. Take care.
Bye.
This episode of The Back Room was edited and produced by me, Andy Ostroy. It was co-edited and co-produced by Maddie Rosenberg and co-produced by Jen Hammoud. Our theme song was composed by Andrew Hollander, and our logo was designed by Cricket Langell. And special thanks to Patricia Wind. Please take a moment to rate and review the podcast, and also follow or subscribe. Until next time, keep your eyes on Washington, Hollywood, and your own backyards, and have a great week.